involved in an act.
Here we go, classic Miranda warning. But notice, the judge isn't just reciting words like a robot. Every phrase is a safeguard against unfair prosecution. Question for you: if you were caught shoplifting $111 worth of items, would you rather pay the fine or risk jail time? Drop your thoughts below.
Accident this morning, so he's not going to be here. So what we'll do is we're going to do probable cause. After that, we'll just give you a normal.
Did you catch that? The judge just banned her from Target as a bond condition. Judges do this all the time, cutting off temptation before it turns into another case. But be real, if you couldn't step foot in your favorite store for months, could you handle it?
They called us to advise you to call the office, and then you guys can get together with them, okay? So ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine.
Here we go. Classic Miranda warning. Notice how the judge carefully lays out every right. This isn't just routine a safeguard. Question for you guys. If you were caught shoplifting $111 worth of items, would you rather pay the fine or risk jail time? Drop your thoughts below.
Violence. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes. Okay. On January 19th, 2025, the officer was dispatched to a Target in regard to a theft. The officer made contact with the complainant, a loss prevention employee, who stated she observed the defendant walking inside the store, grab a shopping cart, select numerous items, place the items inside the basket, and conceal cosmetic items, food, and office items inside her purse. The defendant headed to the register where...
Interesting twist. Prosecutor admits the reckless driving video didn't even look that reckless. This shows how evidence can be subjective. What looks like dangerous chaos to one person might seem like harmless fun to another. Whose side are you on here?
She only paid for the items in her basket before exiting the store and passing all points of sale. The total was $111.28.
All right, Ms. Saldana, I'm going to find that there's probable cause to go forward with the case. Where is this from again?
Target. Yeah.
Target. I'm ordering you as a condition of your bond. Target. Do you understand?
Yes, sir.
If you violate this condition, or if you pick up a new case, a warrant for your arrest will be issued. No more PR bonds, ma'am.
Yes, sir.
So can you file that, please?
Yes, Judge.
I'm going to have you sign a reset. We'll have you take a seat in the jury box while I get your bond conditions. We'll have you sign it, and after that, you'll be free to go. Okay? So Danuna was in an accident this morning, I guess, so he's not going to be here. So we'll just do a regular reset. Just do, I guess, 30, 45 days. And then she needs state's conditions. How are you?
Good, how are you, sir?
Happy Monday.
I'm sorry, I couldn't hear you.
Happy Monday.
Oh, happy Monday.
I have one of our trial cases for tomorrow.
I believe I have one set, but I think he pled his felony.
It's Mendoza.
Yeah, I think he pled his felony. And if not, I will announce not ready, mostly because I got texted some videos last night. Well, I got emailed some videos last night.
Let me pull them up real quick. Hold on.
I feel like he was dismissal if he pled the felony, and then I think they rushed the felony.
Judge, do you have the case number?
I do.
Okay.
2502-101.
And 02.
And 02. They reset it.
I don't see any.
219.
My
Yes.
problem is I have they all overlap, and I swear I have two reckless drivings, each of them with a gun, and one of them called my office to say he pled. I guess it might have been the other one.
Our gun case pled, but the reckless driving is still open.
Okay.
And then it looks like the felony evading in the vehicle got reset to 219.
All right. Can we hold off on that till tomorrow, Judge? Because I came in here thinking that they had pled upstairs. And I obviously got the guy confused who pled upstairs. So let me make some phone calls. Because a client called me to say that he had pled. And I thought it was this one.
What are they doing upstairs? Is there any news?
We're in touch with defense upstairs, and the defendant is going to take the deferred and felony and then dismiss our cases, adding the condition about the firearms, I believe.
Yeah,
You're doing a TRAS? Is that why they did the reset? Are they doing a TRAS upstairs?
This class isn't just a checkbox. It's a test of discipline. Miss 1 week, you're out, and it's straight back to jail. Some argue it's setting people up to fail, others say it weeds out those not serious about change. What do you think? fair consequence, or trap.
Is that why they did the reset? Because a lot of times prior to a plea, they'll do TREDs.
You reset from the last setting without actually agreeing to plea. Kelsey then sent out the email, hey, will you do it? They agreed to plea. I thought my client called me to tell me that he had done the plea. I think he has now agreed.
Did they do the plea maybe? And they just set it to do a TRED?
They hadn't officially done it yet, sir, but I'm talking to the felony defense counsel, and we were hoping you could just come do it tomorrow when this one's set for trial, but we wouldn't actually be going on it because that was the agreement.
Class isn't optional. It's a make or break act condition. Judges use these programs as a test. If you can stay committed weekly for months, maybe you're ready for probation, but miss one class, boom, straight back to jail. Harsh but effective. What do you think? Fair consequence or setting people up to fail?
You will be facing a third-degree felony, minimum of 2 years, maximum of 10 years in prison. Do you understand? For you to complete this successfully, you must do a batter's intervention prevention program, a BIP class. This is tough because this class is you must do it once a week for 18 weeks. And if you fail to go 1 week, they're going to kick you out. You get kicked out. We issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out. You're facing up to a year in jail. Do you understand? It's no joke. No alcohol, no drugs. You must do also what's called a TRAS, an evaluation, to see what other conditions you may need. If they assess other conditions, you have to fulfill them as well. Do you understand? Weapons, no. Harassing, threatening, abusive contact with Brittany Senegal and Chanel Clayton. Mr. Harris, I will make you a deal. If you get this done quickly, I will take you off in half the time. If you're nice to everybody, get your classes done quick, sign up as soon as you start getting this thing, I'll take you off in half the time. You can be done in this thing 7.5 to 8 months if you really kick butt. Be nice to everybody and just don't test positive. Do you understand? Like I said, if you violate this thing, I'm going to issue a warrant for your arrest. You're looking at a year in jail. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses.
You're caught on video inside a high school? That's about as ironclad as it gets. No he said, she said, just the camera rolling. This is why prosecutors love video evidence. It does the talking for them.
I'll find a different case.
Okay.
All right. Thank you, Judge.
You're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you a 15-month deferred. This is a type of probation that if you successfully complete it, you do not end up with a conviction on your record. What you must understand, though, is there is an affirmative finding of family violence in this case, meaning that you ever pick up another one of these cases.
And here's the curveball: organized crime charges over a stolen U-Haul trailer. Sounds dramatic, right? But under Texas law, even a loose group working together can qualify as organized. Do you think that label fits here, or is it overkill?
And it's guilty or not guilty. I will not find you guilty. I will withhold it for 15 months. Do well. Done. 7.5 months. All right. Good luck. Banner. What do you do? What do you do? Say it again.
He's working full time.
Okay. What do you do for a living?
Deliver fine.
Okay. How many kids you got?
So
Okay. Reduce the fees. Yeah. I'm trying to find out. So I'm going to reduce the fees so you don't have to just pay a ton of money for supervision and stuff. My concern is more that you get the classes done, learn from this, so you don't end up with a felony, you know?
yes, sir.
All right. Good luck, friend. Please. Ms. Barrett, you're charged with assault, bodily injury. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, man.
Yes, Judge. The officer spoke with the complainant at Spring High School in Harris County, Texas, and the officer retrieved a video footage of the event. The video showed the defendant turn to the camera stating ready, and then began striking the complainant multiple times with a closed fist to her head and face as the complainant falls to the ground. The complainant stated she felt pain and showed multiple signs of redness on her face.
Okay. It's in the actual high school, huh?
Yes, Judge.
Okay. Ms. Barrett, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person. Do you understand?
That was, I
I want you to listen because these are your bond conditions. If you violate these conditions, I'm going to put you in jail. I'm also ordering you not to be in possession of weapons as well. Do you understand? Do you have a lawyer today? Would you like me to appoint you a lawyer? Okay. Can you file those conditions, please, Alex? Okay. So what I need you to do, ma'am, is, are you 17, 18? You're 20? Are you actually in high school?
high school?
Are you, you don't go to this high school, right?
So I have.
Stop. I'm only asking you. Then you're not to go back to this high school. Do you understand? All right, so I need you to fill out an application for me. Deputy's going to give you an application, and then I'll have you talk to a lawyer here momentarily. Do not leave until you sign our bond conditions, all right? Oh, please. I don't care where you live. I don't care what you do. You are still under bond condition of this court. If you do not have a Texas driver license, and if you do not have liability insurance, you are not allowed to drive. Do you understand?
I haven't driven.
I am also ordering you not to consume alcohol or illegal drugs. If you get called upon to take a test, you must go to a Quest Diagnostics in Dallas, take a test there, and get the result to your lawyer. It is on you to do that. Typically, when we have someone that does it here, they come into here to downtown and they take a test and I pay for it. But because you're over there, I cannot pay for it. You will be required to foot the bill on that. If you fail to go test when you're called upon, I will issue a warrant for your arrest. There are no more PR bonds. You pick up a new case, you violate any of these conditions. Do you understand? One more thing. I don't know what your immigration status is, but if you go to jail and you're not in this country with permission and you spend any more than 46 hours in custody, you will probably get an immigration detainer and it's not going to go well. So if you're not in this country with permission, you better live like you have a halo over your head. You understand? All right. Good luck. Thanks.
And the next one, Your Honor, is sort of.
Just take a
He's also just asking that if he could change the location of his UAs. And I wonder if I could just speak to
Where does he
about
live?
that. In Pasadena, Judge, it seems like
No.
somewhere in South Houston. He said, okay.
Still under bond condition of this court, still required. If some time passes and then he's good, then we can perhaps modify. But this is the beginning of the case. I want to make sure that he's not using it.
Yes.
I don't know him. I've never met him. And so, right, I'm just doing everything that I would do to every single other person. Yeah. You are charged with engaging in organized criminal activity. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025, the officer was dispatched to a residence in Harris County, Texas. In the call notes from dispatch state, the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male, and the reportee lives on Buchanan Street and has camera footage of it happening. A witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and a felony stop was conducted. Defendant Hentoja was observed unloading items from the U-Haul, ran to the back of the residence, and prevented officers from arresting him. Defendants Lopez and Cerda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions.
Yes,
I
Judge.
don't even know where to start.
Judge, my concern is, if you may, I want to bring some, I guess, some points of arguments to the court's attention. The first one, my concern is that, I mean, the 911 caller mentioned unknown parties, and then the police officer later mentions the messed up. without any type of articulable facts, believe that they are the specific people or the individuals that have taken this fuel. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the things, at least under the four corners of the things, allege that my client was involved with this alleged theft.
I mean, remember, like, so when they start an investigation, sometimes they just don't have everything and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul,
Yes, Judge.
and they've given a description of a tall, lanky person,
Yeah.
right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Serta remained in the U-Haul. There's no further information regarding Serta.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality? Like,
And Your Honor,
can you just, does mere presence impute criminality?
Judge, and that's exactly right. Texas law says that mere presence is not enough.
Dude, I'm with you.
Oh, yes, sir.
But, so,
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have that information. We'd have to await the OR, and we don't have at this time.
no,
So-
but I'm not going to sit here and
Yes,
hold
Judge.
someone.
And that's why we defer to the court.
Let's look at what the statute says, because, you know, a person commits an offense if with intent to establish, maintain, or participate in any combination or in the profits of a combination or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. One is murder, capital murder, arson, yada, yada, yada. Two, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number four, unlawful manufacture, transportation, firearms. Which one are you relying on?
Your Honor, as it's pled, is that it's pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence in the information in the DIMS, but right now, Chief is looking at it.
And Your Honor, if we could just maybe reset it for a week or so, we call the witness.
He's in custody, you know, and I can't, I mean, if he was on bond, that would be one thing, but he's in custody. I'm not going to hold him just because, you know. And the compounding it, Casey, is that he's got an ice hold, so I can't.
And there is a surprise twist. No probable cause means the case can't move forward, at least for now. Translation: the state's evidence wasn't strong enough. But here's the kicker. The judge even warns him to be careful who you hang out with. Honestly, that's free legal advice right there. Ever seen someone nearly get burned just by being with the wrong crowd?
Come on, you know?
I just need a little more time, Your Honor, to dismiss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, you know, by all means, but all right, Mr. Sird, I'm going to find that there's no probable cause to go forward in your case. Just, Mr. Serta, be careful who you hang out with, you know? Okay, all right.